can tell.
It's always, you're reading tea leaves the entire time.
Yeah, no, sometimes you can tell it's, I wasn't that confident, but everyone that heard the oral argument, said, oh, got this in the bag. I said, no, I don't think so.
Well, when you're in the weeds of it though, you
You
can
just say, oh, we're now last.
Oh, no, sir, my team.
My fault. All rise. Court of Appeal in and for the Sixth District of the State of Florida is now in session. The Honorable Dan Traver, Chief Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good afternoon, everybody. Welcome to an oral argument session of the Sixth District Court of Appeal. My name's Dan Traver. To my left is the Honorable Petra Brownlee, and to my right is the Honorable Joshua Mize. We have two cases on the docket this afternoon. The first is Peel Holdings Limited versus Riverfront Plaza LLC et al. It's case number 23-644. Mr. Brockmeyer, before I call you to the podium, let me just remind everybody that we are being live streamed and recorded today. If you have not yet silenced your cell phones, we would be truly grateful if you did. Whenever you're ready, sir. And as you know, we typically set 5 minutes for rebuttal, but I can change it depending on your preference.
No, Your Honor, I was going to request the 5 minutes.
Sound great. Whenever you're ready, sir.
Thank you. And may it please the court, again, Alex Brockmeyer on behalf of Peel Holdings. We're asking that this court reverse for two reasons. First, that the trial court erred in granting the summary judgment in favor of Meltzer and Service First by holding that neither executed this guarantee in their capacity personally as guarantors. Second, that the trial court erred in denying Peel's motion for entry of judgment consistent with the non-binding arbitration award when Meltzer and Service First admittedly did not timely request a trial de novo. Now, this afternoon, I'd like to start first with that first issue, the summary judgment issue. And when we look at this guarantee and interpret it, I think it's important to keep in mind a principle that cases like manufacturers leasing, Underco, Roy, Edmund have all expressed when we're considering a guarantee in the context of a corporate debt, which is that we should be sure to try and give effect to the purpose of a guarantee and not interpret it in a manner that results in the corporate debtor simply guaranteeing its own debt, because in that context, we're going to have a meaningless piece of paper that adds nothing to the overall transaction. And so with that in mind, we turn then to the language of this guarantee. And the very first sentence is, I think, very important for this court. It says the following, and I'm going to break it down in a couple of pieces. First, it defines the undersigned as the guarantors and says there are two of them. We know that the undersigned are Meltzer and Service First. That is who our guarantors are, just based on how this guarantee is defining them. Then it goes on to say that the guarantors are doing what? Well, jointly and severally, they are personally guaranteeing and promising to pay Peel the debt set forth in the security instruments. I think that's important on a couple of levels. First, the word personally is saying it's in there. That's what the undersigned are doing. It's a personal guarantee by the undersigned. And it's a guarantee. So we know the purpose of this guarantee is to do just that, guarantee the payment of the indebtedness set forth in the security instruments. That's why cases like Gladding, Schmidt, Compton, that my friend on the other side relies upon, are not applicable. All those cases were instances where the appellate court held there was no language of a guarantee. We have that in this case in the very first sentence. Then we have that joint and several language. That's critical here because it does two things. One, it evidences the party's intent to have the undersigned acting separately from the borrower, McFarland Group 2. And we see that from the cases like Underco and Roy. both instances where the court held that joint and several liability language precluded a signature from being solely in a representative capacity and instead created personal liability for the individual signing. And Underco, I think, is really important for the court to consider in light of Meltzer's first signature, where it has that word personally next to his signature block. My Meltzer's argument really is because my signature is underneath the word borrower, that means I was unambiguously signing on behalf of McFarland Group 2. And Underco and Roy both undercut that argument and shows that it fails as a matter of law. In both Underco and Roy, the individual signature was underneath a corporate identity. And in fact, in both of those cases, the signature was actually preceded by the preposition by. And I'll explain to the court later why that preposition by is important. Yet in both instances, the court said, look, if we look at that signature block in Underco and Roy, that could be a classic example of a representative capacity signature. Yet in both cases, the court looked to the language of the document and said, because the undersigned are personally acting as a joint and several respondent for the debt, that individual was still personally at fault and liable for the debtor, the obligor's obligation, whether in Underco is the lease or in Roy it was the guarantee. So that right there shows why Meltzer's argument fails and why that word borrower over top his signature does not make his signature a pure representative capacity one. Instead, those cases show that his signature truly was personally as a guarantor, just what that first sentence says. And that joint and several liability language, as Underco explains, distinguishes our case from the Delta Airlines versus Wilson case. In Underco, the court distinguished Wilson based on the joint and several liability language in that lease document. Because Wilson's holding is this: absent any contractual language, a signature preceded by the preposition by underneath the corporate name does not create personal liability. But like Underco explains, with that joint and several liability language, we have the very contractual language that Wilson lacked. The other basis upon which Wilson is distinguishable, when we look at the signature block for Meltzer, that first one, the preposition by does not precede his name. That's at record 3256. That was a key component of the Wilson analysis. That preposition by, according to Wilson, was a core component of how the court said there was a representative capacity signature. The two hallmarks of Wilson do not exist in this case. Wilson's not applicable. Instead, we fall more in line with Underco, Roy, Edmund, the cases we've cited in our brief. So that right there shows Meltzer, Service First are truly the undersigned. They are the guarantors. And for that reason, the trial court erred in granting that summary judgment on their behalf. Adam, I think that shows as a matter of law, if this court were to agree with that argument, it could reverse and remand with further proceedings with Meltzer and Service First liable as guarantors. The support for that would be Underco, where in a case postured identical to ours, the second district did just that. But if this court isn't inclined to go there, at a minimum, if you could say we have a patent ambiguity because the interpretation I've just given this court based on Underco, Roy, Edmund, manufacturers leasing is a reasonable one. And when we have that reasonable interpretation, even if this court were to say that the one provided by Meltzer and Service First is also reasonable, which I don't think it is for the reasons I've just explained, but if the court thinks it is, then we just have conflicting reasonable interpretations, which creates a patent ambiguity. And because that patent ambiguity in this case would be centered around the capacity in which this guarantee is signed, then we look at cases like Nation Star Mortgage versus Levine, where the court said where you have that sort of patent ambiguity centered around that issue of the capacity in which a document's executed, then we're going to be getting into the extrinsic evidence about what the parties were giving the meaning to with this document in terms of how it was executed by Meltzer and Service First. And that would be inappropriate for resolution at summary judgment, because in this case, the extrinsic evidence shows that Pial always understood that Meltzer and Service First were executing this document as guarantors. That was the deposition testimony of Pial's corporate representative. And then we look at the other evidence. The fact that the entire basis for this guarantee being generated was prompted by that settlement agreement in the Meltzer lawsuit, wherein Meltzer agreed to get Mr. McFarland released from his original guarantee, which is why Mr. Meltzer approached Pial and its corporate representative, Mr. Tavaria, and said, hey, we need you to get Mr. McFarland released. He wants to retire. Myself, Service First will be the guarantors. After those phone calls, Mr. Meltzer followed that up with an email wherein he represented to Mr. Tavaria, look, here's my personal financial statement. That personal financial statement showed a net worth of somewhere around $35 million. He included the resume of Service First in that email. As the Winfield court explained, an individual like Mr. Meltzer does not provide a lender like Pial with that sort of personal financial information unless that individual is going to be acting as a guarantor of a loan. So that again shows that what we believe is further proof of, if there is an ambiguity and this court's inclined to consider extrinsic evidence, the sort of documentation that creates that genuine issue of material fact that shows why our belief that Meltzer, Service First were executing this as guarantors is actually what happened here. But then it goes even further. We have the November 20th and November 30th emails where Meltzer is copied on those emails. It's represented in those emails that Mr. Meltzer and Service First are going to be guarantors under this guarantee. That's in the record again at 3255 through 3256. And Mr. Meltzer does not object to those statements of him being the guarantor under this guarantee, nor does Service First object. And then we know what happens next. This guarantee is executed. So I don't think this court needs to reach the extrinsic evidence. If this court's inclined to agree with Underco, Roy, in the cases we've cited, it could just say unambiguously, Meltzer, Service First are liable as guarantors. However, if this court is more inclined to just reverse and say, we have a genuine issue of material fact, there's conflicting reasonable interpretations, then as I've explained, summary judgment would have been inappropriate because our extrinsic evidence here certainly does create that issue of material fact. That then takes me to the trial de novo issue. And the plain language of section 44.1035 states that where a party does not timely request trial de novo in the time provided, judgment shall be entered. The second district in Gambrill, the fourth district in cases like Klein and Connell, the first district in the supplemental authority, my friend on the other side has cited the Smith versus Bright case, have all held that the legislature said what it meant and meant what it said. Judgment shall be entered. That is a mandatory act that must occur. Trial de novo, as Meltzer and Service First admitted to the trial court, was not timely requested. So what the trial court we submit should have done was enter judgment consistent with the non-binding arbitration award.
So do you believe that the trial judge would have had no discretion whatsoever to extend the time for that under Rule 1.090?
I do not, Your Honor, because it's the statute that mandates the
Statute says in the time period provided in the Florida Rules of Civil Procedure. And the Florida Rules of Civil Procedure contain 1.090 which apply to the rest of the rules, including 1.820, don't they?
Well, I don't think it specifically references the rules of civil procedure. It just says within the time provided. But I agree that it makes the most sense that we're talking about the rules of civil procedure. So I'm not necessarily pushing back on that statement, Judge Mize.
But they also weren't considering that. The second district at least was not considering Rule 1.090 in the Gambrell case. Is that correct?
I don't believe that issue was raised, Your Honor, but it was seemingly before the court in Smith versus Bright because the concurring opinion there mentioned it, yet the majority said we're talking about a bright line mandatory rule. Judgment shall be entered.
What do you take of their, because like, Gamble, obviously, the court didn't consider 1.090 or didn't discuss it. There argue that there's other second DCA cases that predate that go the other way. And, DCA judges disagree whether panels bind another, but you'd assume if one panel's overruling another, they would at least talk about it, right? We assume courts don't overrule each other sub silentio. And so if we assume that the one panel wasn't overruling another, how can we possibly read Gamble the way you're saying in light of the prior cases from the second DCA going the other way?
Well, I think the way we can harmonize them is that we look at the time provided. Once that time provided has elapsed, judgment must be entered. I believe that the cases Your Honor is referring to was contemplating extensions for snail mail back before we amended the rules of judicial administration for mailing in 5 days. That was something that was automatically done. That timeline extended the time provided to request a trial de novo.
Where did that time frame come from? What rule
Well,
back then?
the rules of judicial administration provided.
For that 1.090.
Yeah, no, and I'm not suggesting that the 1.090 does not provide the time. All I'm suggesting is that once the time set forth in that rule the rule provided for has expired, the legislature, the statute says judgment shall be entered. And I think what we could be doing is running afoul of the mandatory language in the statute by our interpretation of that generic time computation rule. If someone were to move before the time provided expired and said, hey, Your Honor, trial court, let me get an extension of time, and it was granted, not arguing the 20 days would be fine or would have expired, judgment would have needed to have been entered. Different story. The time provided is larger. All I'm saying.
Well,
If you're conceding, I'm sorry, go ahead.
Go ahead, I think we might have.
If you're conceding, it could have been extended under 1.090 prior to the deadline expiring. 1.0 explicitly says you can extend deadlines after.
That's a generic rule. We have a more specific rule for the non-binding arbitration timeframe and guidelines about what happens when that time expires.
But this isn't a case where you have 1.090 is not just doesn't just generally speak to deadlines. It specifically modifies the other rules. This isn't the case where you have two things and one's just general, one's more specific. 1.090 explicitly states that it can apply to the other rules. So it's not that they're in conflict and specific controls over the general. One states that it modifies the other.
And I am focused on the statute that says when the time provided has expired, judgment shall be entered. That's what Gambrell and the 4th District, the 1st District have focused on. But if this court doesn't agree with me on that, still on the merits, reversal is warranted. And so we would request this court reverse, as I've stated, on the merits. And as to the Travanovo issue, you could reverse as well. Thank you.
Good afternoon. If it please the court, I'm Robert Stock, and I represent the appellee, Mr. Meltzer, and Riverfront. The first issue I'd like to address is the issue of the trial de novo. One issue that was not addressed at all on appeal was the fact that the non-binding arbitration was never properly noticed in the first place. The rules of procedure of the non-binding arbitration pursuant to the statute were required to be submitted along with the notice. They were not.
Let me echo the trial court. Why'd you do it then?
Why did I do it? I
Why'd you do
mean,
it? Why'd you waste the money if it was non-binding? Why'd
we,
you waste your client's money if it was non-binding?
well, we did it because, I don't think at the time when we did it, we really realized what the technical issues were. But the fact is, if the rules were provided it would have given us an extra opportunity to make sure
It's a
that,
tough argument for me to take, Mr. Stock, because ultimately, it seems to me that there might have been a situation where like you wouldn't have been raising that issue. So in that sense, maybe the arbitration could have gone differently for you. Maybe everybody would have been at peace with it. In that instance, it's a waiver, right? Certainly, it's a waiver of any pre-arbitration.
yeah, I mean, I suppose, I guess it's like in the football when the ref calls a penalty and but the play is in motion and the quarterback throws a touchdown, he's gonna deny the penalty.
I guess I'm a little bit surprised that out of everything that you have available to you, you're leading with this, you know, because your associate was the one who argued what ultimately ended up being the meritorious issue, which is 1.090. You've heard the panel's questions to your colleague, Mr. Brockmeyer, and it's just odd to me that you would come up with this as your first issue when it was so clearly waived.
Well, I mean, I agree with you that the notice issue was not raised and we went to arbitration. What I'm trying to point out is that when you're dealing with a technical issue, it's disingenuous for one side to say, we didn't follow the rules, but you have to follow the rules to the extent that if you're even one day late, if you're even one of the lawyers had a tragedy in their family, and the secretary was out on maternity leave, and the office was shut down by COVID, tough noogies. You're a day late and $1 short. And on
the
the,
difference there, one side waived it and one side didn't.
I don't understand.
In other words, I think what Judge Traver has said is you waived the issue, whereas they didn't. They went in and said, all right, Judge, they missed the deadline, give us a judgment. Right, like they didn't waive their technical issue, whereas you waived yours.
Well, I mean, that's one
It'd be a
aspect
pretty
of
easy
it.
way to harmonize those two positions, right?
Yeah, I agree with you, but the point is, when you don't do things properly and things don't work out the way they're supposed to, the rules are there for a purpose. I assume that the reason why the rules have to be provided is to make sure that it's like a railroad crossing. There's a stop, look, and listen component to that. And here, we made a mistake. We didn't calendar it correctly. We didn't file the notice on time. Even if it was waived, I think it's in part attributable to the failure to follow the rules. And I think that's important. The other thing is, they didn't, in all the cases that they cited, Gambrel, in all the cases, after the court did not act in what they considered to be a ministerial function, they filed for a writ of mandamus. Here, they went ahead and litigated the case for a whole year. And then when it didn't work out to their advantage, then now they're screaming foul. And I think that's the real waiver here. The waiver is that they allowed the case to continue for a year and did nothing. All the cases that
You don't have to, I mean, if you analogize that to like an interlocutory appeal, you wouldn't have to, do you agree with this? That you do not have to take an interlocutory appeal and instead,
yes, I do. I do agree with
you could just wait till the final judgment was entered and then do your final appeal. So
But this is different. This is they're saying that there's no discretion. This is a technical issue and it should have been entered immediately. But then they go ahead and they waste all these judicial resources to litigate the case for a year. So I don't think it's
arguably, it would have been of no moment if they prevailed at the end.
okay, but I mean, if they didn't immediately seek the relief, I think that they left themselves, that to me is a very significant waiver. If they're so confident that they're right, why didn't they say?
Council decide with you on that? Would we have to write an opinion saying now people do have to file interlocutory appeals? You can't wait till the end or you waive it?
Well, there is case law in that, and actually we cited it. That when it's a ministerial act and you go ahead and you litigate the case, there is a waiver to it.
But to agree with you on that point, we would have to find that this is a ministerial act and the trial court had no discretion whatsoever to extend that timeline under Rule 1.090?
No, all the cases that have considered the issue at this point have all decided, except for Gambrel where the issue was not raised, all the courts have said that the court has discretion to consider, an extension under 1.090, if there are, circumstances that justify it, excusable neglect. And here, at the hearing on the motion, Pial accepted the representation, that we made, that there was a very severe illness in the family of the, lawyer that was, working with my firm. His father was diagnosed with cancer. He actually spent 2 days in the hospital. He was out of the office most of the time. The secretary that was supposed to calendar it was out on maternity leave. The office was closed for most of the time because of the COVID pandemic. So there were very, very severe and quite remarkable issues that caused this excusable neglect. Getting to the issue of the guarantee, it was represented that the first sentence of the guarantee refers to 2 guarantors. It doesn't. It just says the undersigned called guarantors. So there is no reference.
Potential influence of, is a potential implication of the plural, meaning more than one?
It says guarantors, so there could be 2
Does that mean more-
guarantors.
Does that mean more than one in common English?
Yes, it does, but it doesn't say 2. It could be 3, it could be 4,
How many signatures are there on the document?
2.
Okay.
But
Is
we're
that more than
talking
one?
about what the guarantee says, which is different from,
Can a single person be jointly and severally liable by the person's?
of course not, no. But what I'm trying to point out is that the guarantee does not say that there are 2 guarantors. The argument that we would have a situation where Mr. Meltzer would guarantee his own debt if he was signing on behalf of the borrower does not take into account the fact that the loan restructuring documents contemplate a shift in the mortgagor from McFarland Group Roman numeral 2 to Service First.
Where do you read that?
In the restructuring documents,
Could I please have a record site?
yes.
Are you referring to the amended mortgage, which refers to the update to 18K
I'm not sure,
default provision? The one that refers to Metivier only?
I'm not sure. Am I referring to what? I'm not sure I understand.
So the amended mortgage, the restructured mortgage has and there's an allusion to it in the amended note as well, talks about an update to 18K, which is the default provision in the original mortgage. Are you with me so far?
No, I'm not.
So-
What I'm,
So let me go back to my initial question, and you made a statement that basically said that Service First would be the successor mortgagor. Where are you getting that from in the record?
it doesn't say that they would be the successor mortgagor. They said that they would be a permitted transferee. In
Where is
other,
that?
oh my gosh. I think it's the record at page 591 is where is the
What
record.
document is that?
I believe that it's the loan restructuring agreement. It says that Service First is a permitted transferee. So if the mortgage was transferred to Service First, in that case, Service First, who clearly was contemplated to be a signer on the guarantee, would be guaranteeing its own debt.
So then
And-
why are there 2 signatures on the guarantee?
Because of the contemplation that the mortgage would be transferred from the McFarland Group or Riverfront Plaza, as it came to be called, and Service First. And that was what I believe that was the function of the guarantee. In all the cases that they're citing to say for the proposition that a guarantee, that in this case, that the guarantee should be enforced against Mr. Meltzer, in every single one of those cases, there's language in the guarantee itself indicating that the guarantor is accepting personal responsibility for the guarantee. Or there's signals in the signature that the individual is accepting personal responsibility for the guarantee. In the situation where they give their personal information, their personal address, their social security number, things like that, to show that the individual understands that when they're signing that document, they're personally responsible.
Other than just the word personally.
Well, that, under the Delta Airlines case and under a whole series of cases, some of which Pial is relying on, the word personal, the descriptor personae, as it's called, is virtually irrelevant. I mean, Mr. Meltzer is an elderly gentleman. He came to sign these documents. He wasn't represented by counsel. He sees the rubric borrower. He signed under the borrower. He didn't write in that I'm personally liable. There was nothing to alert him to the fact that
Real estate developer,
he is a successful real estate
first time
developer.
you'd ever seen a document that said guarantee before?
No,
Let me take you
absolutely
back to my
not.
earlier question. That document that you alluded to is the amended mortgage. Paragraph 3 of that document is the only paragraph that references Service First, and it talks about transfers from Metivier only. It doesn't mention the borrower in there. So is there
Correct.
another place in the record that you're alluding to which says?
No, that's the only place, but
Where do you get that Metivier could transfer its interest, which is clearly in the wake of the settlement agreement between Mr. McFarland and everybody else in
okay.
the transaction? Where do you get that Metivier could transfer its interests purposeful to that settlement agreement? Where do you get that the borrower could then somehow switch its interest under the mortgage to Security First as a matter?
Well, if they're a permitted transferee, then that could happen. However, as we know, Metivier was never a mortgagee, so they had no interest in the mortgage that
That
could have
doesn't
been.
help your statement that that's the document that shows this particular point of fact. I mean, if I were the lender, wouldn't I want to sign off on the notion that I might have a new borrower by virtue of an assignment?
I believe that that's what the purpose of the guarantee was, to show the shift in liability from the McFarlane Group to Service First. They talk about the email where Mr. Meltzer provided information. There is no such email from Service First. There was no inquiry into Service First's assets. And in fact,
Didn't you hold 100% of Service First assets?
no, he actually.
Aren't you skipping a level? Like, so the idea under your statement is going to be that we're skipping TMOG2, and then we're going right to Service First and Metivier type level and saying that somehow this restructured loan transaction contemplated that Riverfront could assign all of its interests under the mortgage and its debt under the mortgage to Service First. Again, the document that you cited, 591, doesn't say that. Is there anything else in the record that says that?
That's the only reference that I know of where it said that Service First would become a permitted transferee. So that's what I believe that the guarantee's function was, to show that there was going to be a shift in liability between the McFarlane Group and Service First. To glean from the word personal that Mr. Meltzer was put on notice that he's going to be responsible for a $10 million loan without any indication or mention in the loan itself that he's going to be personally liable, would be to ascribe to this particular agreement import that it didn't contain. Every single one of the cases where personal liability was found were cases where either in the guarantee itself it referred to the person, or there were other signals indicating personal liability in the manner in which the guarantee was signed. It shouldn't be that a panel of judges has to decide what was meant by the guarantee. It should be clear and explicit in and of itself. And in this case, it's not.
So what about that? If we I think that you're latching on to the word personally after Meltzer, after borrower, but even throughout, I mean, wouldn't we, to take your argument and to accept your argument, wouldn't we have to read out so much language of this guarantee, including the initial sentence, which reads, the undersigned, called guarantors, plural, jointly and severally, unconditionally and personally, guarantee and promise to pay, ... So we have to read that out, and we have to read out the word personally. And we would have to ignore that the document also uses the terms guarantee and borrower as separate and distinct terms. We also have to ignore that. It just seems to me that there's sort of a plethora here that we would have to ignore in order to accept what you're telling us about the
Well,
word personal.
You make a very good point. However, suppose there was another piece of paper, same guarantee was signed by a third person. Would there be anything in the guarantee that would say, no, that person is not the intended guarantor? It's Mr. Meltzer that was the intended guarantor? I submit that there wouldn't.
Would that be called like would it be like an amendment to this, a superseding document?
It doesn't even have to be an amendment. After Mr. Meltzer signed this, there could have been another document, the same guarantee, where it said guarantor, and it was signed by a third party, clearly indicating that it was intended to be signed by an individual. And you wouldn't know from the language in the guarantee whether or not that individual was intended to be the party to sign the guarantee or not. That's the point. There is no specific language in the guarantee that such as I hereby promise to guarantee this debt, the full extent of the debt. That's what someone needs to be alerted to when they sign a guarantee. I mean,
What about where it says this sorry, Chief Judge, would you like to go?
This exact same question, go for it.
What about, I think it's either the penultimate or the final paragraph. The guarantee is absolute and unconditional and is not subject to any conditions. And this might be what you're talking about here. Guarantor is fully liable to perform all of the borrower's duties and obligations under security instruments as of the date of execution of this guarantee.
no, I understand that, but there's no acknowledgement by Mr. Meltzer that he's accepting that responsibility. There's just simply a
Other
signature
than the
under the.
signature that says personally underneath it. Let me ask you this way. Assume for me that the word borrower in above the signature block isn't there. What's your best argument in that case as to why this isn't a guarantee?
I would say under that case, which is not the case that we have, obviously, I would say under that case, it's not explicit that he's assuming the duties of a guarantor. It doesn't say, I, Oded Meltzer, personally guarantee this debt. And under all of the canons of interpretation of guarantees, we have the statute of frauds, and we have the doctrine under Fink and other cases where documents, contracts are construed against the drafter in the cases of ambiguity. And when you have a situation where it says borrower and someone signs thinking that they're signing on behalf of the borrower, they shouldn't be hauled into court and sued as a guarantor.
So I understand your argument with the word borrower, but in response to the Chief Judge's question, if the word borrow wasn't there, it would still need more language. I'm really struggling to imagine what language that could possibly be. Like, how would you write a guarantee differently than this?
I would say,
What's the language that's missing? Like, give me some specific
great,
words.
I appreciate that opportunity. I would say Oded Meltzer, individually, and as the manager of Service First, do hereby guarantee blah, blah, blah. And then I'd have all the specific language, and I would mention Meltzer and Service First in the body of the guarantee. And that way it would be unmistakable. And then under the signature line, first of all, I would have guarantor, colon, a big block rubric. And then I would say Oded Meltzer, individually as guarantor, and Service First as a guarantor. And that way we wouldn't be having this argument. It's incumbent upon the party that's the proponent of the contract to make it absolutely and indubitably clear that.
Your past time.
Okay, well, thank you very much.
Mr. Rockmeyer, you have 3 minutes.
Thank you, Your Honor. Again, may it please the court. Focusing on the guarantee issue. The permitted transferee argument, Judge Traver, Judge Brownlee, record page 591 that my friend on the other side relied on, it does not support the argument that Service First is trying to make, that that's the purpose of this guarantee. And if you reject that argument, then looking at pages 28 through 29 of the amended answer brief, if that argument's rejected, then we know Service First has agreed it's a guarantor. The undersigned argument,
Let me ask you the flip side of the question I asked Mr. Stock. What are we to make of that big, bold borrower on loan documentation that was effectively financed by your client, albeit with his, with your law firm, working for him? How do I have that? So the way that it worked is Mr. Taviera and Pile Holdings didn't pay for the revised loan documents to be created, correct?
that is correct, and it's also that was in the corporate representative, Pial's corporate rep deposition. He also testified that Pial did not draft these loan documents. That's record 2359, lines 11 through 14.
Didn't he also have the testimony, though, that said he could basically make whatever edits he wanted to make to it? So you've got a situation where you've got borrower in all caps above the signatures. I think you'd have to concede that that doesn't make it more clear that it's a guarantee. How much damage does that do?
I don't think it precludes reversal, because on my worst day, it's a patent ambiguity. But under Underco and Roy, and especially Underco, it means still, because of that joint and several liability language, that the signature can still be a personal obligation on behalf of Mr. Meltzer. Because in Underco, the lease agreement said the person signing is jointly and severally liable. In Roy, it didn't identify Mr. Roy by name. It said the undersigned is jointly and severally liable. Joint and several liability on behalf of the undersigned was the same terminology used in manufacturer's leasing in Edmond. And so I don't think it precludes the interpretation I'm urging for as a matter of law, that Mr. Meltzer is personally liable as a matter of law. Well, on my worst day, it's just a patent ambiguity that would be fit for resolution at a bench trial or a trial, not at summary judgment, Your Honor.
Did anyone ever inform the trial court as to, was there ever any summary judgment evidence or anything put forth for the trial court to explain why the word borrower is there?
I only believe that the corporate representative of Pial's corporate rep was there, and that was certainly before the trial court. It was explained that they were always supposed to be guarantors, but there is nothing that explicitly says this is why borrower was or was not there, Your Honor. But I would request this court to reverse for the reasons I've stated. Thank you.
Thank you. And we will be in recess until 2 o'clock.
Your Honor, I made a inadvertent error in the record site. It's the permitted transferee language is on 581 paragraph 4. Thank you.
All rise.
All right, we're back on the record. Please be seated. This is our second case of the day. It's JC Resources LLC versus Optum RX as the successor by merger to Catamaran Corporation and Optum RX in its own right at all. I'm Dan Traver. I'll be presiding today. I'm joined by the Honorable Petra Brownlee and the Honorable Joshua Mize. We are live streaming on YouTube and recording. So if you haven't turned off your cell phones yet, you would do us a tremendous favor by doing so. Counsel, 5 minutes typically for rebuttal. Would you like 5 or would you like more or less? Whenever you're ready, sir.
Thank you, Your Honors. Mark Rosen from the Jacobs Law Group, PC, for the appellant. There are 3 issues I'd like to discuss today. The first deals with the Federal Arbitration Act. The second deals with the Florida Arbitration Code. And the third, to the extent I can get to it, deals with the unconscionability. The key thing is the Federal Arbitration Act was written very carefully back in 1925, recent history. But they said Section 2 deals with the policy favoring arbitration. But they set very different terms of Section 3 and Section 4. Section 3 deals with the case when someone files suit when they're subject to an arbitration agreement. And in that situation, the phrase is proceeding brought in any of the courts of the United States to compel arbitration. Section 3 deals with the opposite situation where there is no suit pending, but there's an effort, there's a refusal by a party to participate in an arbitration. And it's not, and under those circumstances, they say, may petition any United States District Court. So at the same time they drafted the statute with Section 3 saying any court can do this. In Section 4, they said only federal district courts can do that. And so it's clear that Congress contemplated a very different regime. So if they refuse to arbitrate, if they file a suit under Section 3, you can enjoin it. But if they are declining to participate in an arbitration, you have to go into federal district court. They did not do that. And in fact, Section 3 says, not only, Section 4 says rather, not only do they have to do it in federal court, they have to do it in the where the contract calls for arbitration in a specific forum. In this case, Los Angeles or Orange County, California, you have to go to that federal court, namely the Central District of California, to bring that action. That wasn't done here. Now, Optum points out to a couple cases in Florida jurisprudence which referred to arbitration under Section 4. But neither of those cases did they actually enforce it. In Basalto, they said, we're declining to.
Sorry, counsel, are you referring to cases stating that Florida courts have concurrent jurisdiction with the
Yes.
federal courts?
Yes,
Okay, and so your position is those are of no moment?
they are of
Because
no moment because in neither case, neither in Basalto nor
What
in.
would jurisdiction do if not allow them to enforce the law?
I'm sorry, Your Honor.
What would a Florida court having concurrent jurisdiction mean if it didn't mean they could enforce the arbitration act?
It has concurrent jurisdiction if a Section 3 claim arises, namely if JC Resources filed suit against Optum, Florida court could grant relief under Section 3. It could not compel it to participate under Section 4. That is reserved exclusively for the federal courts. And neither in Basalto nor in Grant versus Rhode Island did they find that those cases were subject to arbitration. Both cases, they declined to do that. And I don't think that's an accident. And the 11th Circuit was the same way in the Ultra Kashmir case, where they were talking about Section 3, not Section 4. They said, let me give you the exact language. Enforcement of the act is left primarily to state courts, federal courts being authorized to adjudicate only arbitration disputes that are otherwise within the jurisdiction, citing Section 4. Moreover, the federal court's jurisdiction over even this limited number of suits is not exclusive, but rather concurrent with the jurisdiction of state courts, citing Section 3. So even the 11th Circuit said Section 3
all's fair. State court, federal court, but that's when but if JC Resources or Gulf Shores, it's sometimes referred to, had filed suit against Optum. But if the claim is that they've refused to participate and there's been no refusal, but if they affirmatively refuse to participate in arbitration, then they could be brought under Section 4, but only under federal district court. Now, the other issue is whether they've refused to participate. And there's,
If you had a case that where the federal court did not have jurisdiction, right? There's no diversity and the underlying claims don't involve federal claims, so they've got to file in state court. How does Section 4 end up being operative?
you have to have jurisdiction under those circumstances. They were very clear in writing the Federal Arbitration Act. It is not a grant of general jurisdiction.
Well, that's my point, right? So you've got claims that are subject to arbitration.
Right.
Right? A person bypasses the arbitration, sues anyway, but they have to sue in state court because they're not federal claims and there's no diversity jurisdiction. In that case.
No,
if
no.
State courts can't enforce Section 4.
They
How does-
can't, but they can enforce Section 3. Namely, the Section 3 addresses the problem of if JC Resources sued Optum. They did not. The only right they have is with respect to Section 4, and then they have to go into federal court. And there was no outright refusal. What in fact I think happened, and this is directly analogous, we filed a notice of supplemental authority referring to a case Optum versus ANS, which was decided very, very recently.
How would you go into federal court with that if the Federal Arbitration Act is not a grant of jurisdiction on its own?
You wouldn't.
How many of our sister courts do we need to certify conflict with to accept this argument? 5, right?
No, I don't believe that's so. What went on is there are a series of appeals being argued right now. King's Drug was argued last week or the week before. I'm arguing VistaCare and another one the next week. I suspect all this will end up before the Florida Supreme Court. But there are 14 cases
My
that were
question is
closed.
just how many of our sister courts we need to certify conflict with to accept this argument that you're making.
I can't tell you the answer to that, but I do know that the trial courts,
So minimally, it's the 5th with Rodolente and, I'm sorry, Grant v. Rodolente.
right,
And Della Pena v. Zabawa. The 3rd as well. I can't recall the name of the case. I'm not sure about the 2nd. Seems like a few though, right, that you're asking us to certify conflict with?
what I'm asking you to do is read the statute as was written.
I get it, but if none of our sister courts has read the statute to accept your premise is true,
But-
in a completely convoluted, illogical way.
But
and we
they've
rule
read it in
differently,
a way
don't we
that,
need to tell the Florida Supreme Court. I just need to finish really fast.
sorry,
Um,
they've read it in a way.
should I finish?
Sure, I'm sorry.
So we definitely need to tell the Florida Supreme Court that we're certifying conflict, right?
I have no doubt.
Okay, so who are we certifying conflict with?
You're asking me to enumerate the district courts of appeals? I can't do that. But the point is, Section 3 jurisdiction exists, Section 4 jurisdiction does not exist. And the next one I'd like to address very briefly is the Florida Arbitration Code. The case of Demora, the Florida Supreme Court, not a district court of appeals, held that when the contract specifies the law of a jurisdiction other than Florida to govern, and it's beyond dispute that the contract says California law will govern, they have opted out of the Florida arbitration system, and the Florida courts lack the authority to overturn that. Demora is still good law. Even though the Florida Arbitration Code was amended in 2013, Demora was not based on any language in the Florida Arbitration Code. It was based on the fact that
The language basically saying that, I believe the language that was deleted in the amendment said, this statute does not apply when parties are stipulated to the statute not applying, and by choosing out of state law, you're opting out of the Florida Arbitration Act.
here's what the Florida Supreme Court said in Demora. It is our opinion under the contract terms, Florida Arbitration Code was rejected by the parties by reason of their agreement to arbitrate in New York City. The Florida courts have no statutory authority under Chapter 682 to compel arbitration in another jurisdiction. They said nothing about the language of 682 that's changed. It was the same provision then as now, as it relates to this point.
Judge Mize was, I think, quoting 68202.
Yes,
The FAC shall not apply to any such agreement or provision to arbitrate in which it is stipulated that this law shall not apply.
but that's not what Demore was based on.
What was it based on?
Demore was based on saying it's beyond their power, that when a contract says it will be governed by the law of a state other than Florida, Florida Arbitration Code does not authorize a Florida court to order it to be arbitrated outside of Florida. You look puzzled. The last point, and just to put a point on this, I draw your honor's attention to the Supreme Court's opinion in Volt, which is 49 US 468, decision by Chief Justice Rehnquist in 1989, in which he said, talks about the distinctions. He said, Section 2 of the Act declares that a written agreement to arbitrate in any contract involving interstate commerce shall be valid, irrevocable, and enforceable, except on such grounds as exist. And it says, Section 4 allows a party to such arbitration to petition any federal district court for an order. The only cases that have suggested Florida has power under Section 4 were cases where they in fact did not order an arbitration, namely Basalto and Grant. The last point I'd like to address very briefly.
So then is it your position that we would not need to certify conflict? It seems to me that you're saying these cases are distinguishable. The cases relied on your adversary here. So if that's true, then do you disagree with Chief Judge Traver's point of wouldn't we need to certify conflict with other district courts of appeal? I mean, either they're distinguishable or it's direct conflict.
Well, I think they are distinguishable. Specifically, Basalto said, we're not ordering arbitration. Grant versus Rotolande said, we're not ordering arbitration. So I think they are distinguishable. But if there's the desire, but I suspect with the 14 cases percolating through the various district courts of appeal, somehow one or more of these cases are going to end up in the Florida Supreme Court. That's what I expect, but I can't predict it. I want to draw your attention back to the third point I'd like to make, which is the unconscionability. And in that case, I want to draw your attention to the Marinette case, which we cited in a reply brief. I can give your honors the Westlaw site, which is 2023 Westlaw 4485-615.
I was interested in that issue and I looked at the notices of supplement authority, and I believe it was a Central District of California case where the court essentially said, I don't really think there is a delegation clause here. It kind of parsed the language of the arbitration provision and basically said, and I thought made a compelling case that the portion of the provision talking about the threshold issues was actually not subject to the arbitration language. And you all, you filed that notice of supplement authority, I think, and I thought it was a really powerful. Problem is you didn't argue that here. You didn't argue it on appeal. You didn't argue it below. So if I think the notice of supplemental authority you gave us is correct, that there actually was no delegation provision to begin with, how do I deal with that? How do we deal with that, given that you failed to raise that below and failed to raise it with us?
Well, you can certainly ask for a supplemental briefing, which we'd be happy to provide.
I mean, you didn't raise it below, right? It wasn't, this has not been argued anywhere, right? So you argued below and here that there's a delegation provision that's unconscionable.
Yes.
And then you filed a notice of supplemental authority, which I thought was a very well-reasoned case, saying there is no delegation provision that could be unconscionable. And if I agree with your authority that there is no delegation provision in this arbitration provision, what do I do given the fact that you didn't argue that to the trial court below and you didn't argue it to us?
Well, you have to understand the trial court below decided this issue without any findings of fact whatsoever.
Well, I read your briefing below, counsel. I mean, you argued that there was a delegation provision and that it was unconscionable, very similar to the argument you're making to us.
Yes.
You did not go to the trial judge and say, Judge, there is no delegation provision.
I wasn't standing there, so I can't tell your honors what I would have done.
I mean, you were counsel.
No, I was.
You did the same lawyers in the Central District of California case, correct?
Yeah, but I only joined the firm in May, your honor, so I had no involvement with that case.
Okay.
So I wish I could give you a good
Do
answer,
you
but
think that case was correctly decided?
do I think which case?
Like Central just, it was Optimex Inc. versus ANS Drugs.
Yes, I
LLC.
think that was absolutely correctly decided. And what is most significant about that,
But I'm saying, if I agree with you that it was correctly decided, what do I do here? What do we do, given that the court's decision is reliant on, I think, a correct argument that you failed to raise here and below? What would that lead us to do?
well, I think what it ought to do is turns back on the defendant's issue about what the proper response would have been. ANS said, I construe the agreement, the agreement with Optum to say, you are required to confer for 30 days and resolve this. And you have not done so, and therefore I'm dismissing without prejudice. That's exactly what Mr. Cooper's letter did in December 2023. He listed 8 bullet points of issues of concern to 500
Issues
pharmacies.
of concern, or did he call them disputes?
I think the phrase was dispute, but that doesn't qualify, not even.
Why was the language changed? Like, if I was arguing to a court, right, I'd want the language of my brief to kind of match the record as closely as possible, so the court could follow my argument when it looked at the record. Why did the brief use this issue of concern language when the letter just says disputes?
I can't answer your honor that.
I mean, disputes is a term of art under these documents, correct?
It is and it isn't. The fact that you're identifying the dispute doesn't mean I'm ready to file suit. There are a series of cases. There's the Third Circuit case in Payne-Weber versus, I'm gonna get the last name wrong.
I'm gonna let you finish your point, but due to some operator error, you're into your rebuttal time and you're like.
All right, I'd like to stop then.
So you've got 4 minutes left, but if you want to finish the thought, by all means.
So all that I was gonna say is, the Third Circuit said in Payne-Weber that doesn't constitute a dispute, that merely raising an issue, merely saying you have just questions about arbitrability, even suggestions in the labor management discussion about whether it's subject to arbitration does not constitute a refusal. So I want to reserve the remainder of my time so I can answer my colleagues'
We'll have 3 minutes and
Argument.
40 seconds.
May it please the court, Michael Polachek for Optum Rx. Your Honor, I want to start with jurisdiction, please. And I think the easiest way to resolve the jurisdiction issue is to follow the line of cases that even during the Demora rule before 2013 said that rule doesn't apply when a contract is governed by the FAA. We cited 6 of those cases in our briefs, and in prepping for this, we found a 7th case, the Trojan Horse case that we submitted to this court last week. And so you have 7 times that this issue has been raised to a district court of appeal of what do you do under the Florida Arbitration Code when a contract is governed by the FAA? And in all 7 of those cases, the court held that, to the extent that there is this Demora rule, to the extent that Florida courts won't apply the Florida Arbitration Code when the parties have stipulated to have arbitration elsewhere, if the FAA governs, then the court has to enforce that agreement.
Can you tell us what's going on in the 2nd and 5th district cases? You cited in your brief just a little footnote saying that the motions were denied in those cases on jurisdictional grounds only, and that they're pending in the 2nd and the 5th. Can you give us a little more detail on that?
Yes, Your Honor. So just to be clear, you're referring to our cases, not Optum. So yes, there have been 6 decisions in the circuit courts on this issue. This is one of them. In 3 others, the courts granted our motion to compel arbitration, finding jurisdiction, finding the arbitration agreements enforceable. In 2 of the cases, the 2 that Your Honor referenced, the court denied our motion based solely on jurisdiction. One of them is the King's Drug case in the 2nd DCA. That oral argument is scheduled in January.
The trial courts basically agree with their Section 4 argument. Is that what happened?
Correct. They agreed with the Section 4 argument. That is correct, Your Honor.
Can I ask you about the Central District of California case and what you make of it? Because I thought it was a pretty well-reasoned case. And I looked real closely at the language of the arbitration provision. And I think, I don't know the judge's name in the Central District, but I think that judge made really good point regarding the language of the arbitration provision. It doesn't look like it has a delegation clause to me. What do I do with that?
Yeah, you're on two responses. One is I definitely do think this is waived. It was not raised in the trial court. It was not waived here. We repeatedly stated that there's a delegation clause. They agreed. Their only argument is that it was unenforceable, not that there is one. Second, I don't read the judge, I believe his name is Judge NL Roca's, ruling the same way. I think that he does. There's a suggestion there that the
The
delegation.
language of this paragraph, I'm quoting from it, does not clearly establish an arbitration agreement covering any and all issues, disputes, or controversies between the parties that clearly and unmistakably delegate arbitrability to the AAA.
Your Honor, getting to the holding though of that opinion, it's that that we did not certify that we had this meeting between the vice presidents, and it denies without prejudice and allows us to refile it. We're conducting that meet and confer now. We plan on refiling it. We don't read that as
He's right, it says, he goes, the court finds this provision imposes instead an obligation on the parties to work together in good faith as set forth below to resolve their disputes, and delegates to arbitration only disputes relating to the network pharmacy. Basically not the threshold issues, right? Not arbitrability itself. And
if that judge, did find that there's no delegation clause, we're going to be back in front of that judge filing another motion because the judge denied it without prejudice and said we can refile it. We think there's no question under the scope of the arbitration clause that these disputes are covered by the delegation clause. I will say though, moving to the second point, that even if Your Honor finds that there's no delegation clause here, all that means is that it's up to the court to decide whether the arbitration agreement is enforceable or not. It's not something that's delegated to the arbitrator. Here, there's just been a complete failure in the burden of proof by the challenger here, by JC Resources, to show that this arbitration agreement is not conscionable. You can look in the record in 1,000 pages. There's not a single declaration, affidavit, anything from JC Resources saying that they didn't see this arbitration agreement.
well, that goes to the merits of unconscionability. And it wasn't clear to me that the trial judge ruled on the merits versus finding that validity and enforcement was delegable, right? The judge did rule from the bench, right? And gave no oral ruling, and the order is pretty, is pretty sparse. I couldn't tell from the order, and if there's something I missed, please let me know, whether the judge found that these issues should be delegated, right? And he wasn't ruling on the validity of the arbitration provision or enforceability, or whether he, found they were not delegated, but ruled on the merits that it was in fact valid. He just said, the dispute shall be arbitrated. He didn't break down the disputes over validity versus and unconscionability versus the merits disputes. Is there anything in the record that tells us whether the judge decided the delegability issue?
There is not, Your Honor, nor was the trial court required to do that. I mean, the statute just says that if there's an opposition to a motion to compel arbitration, the trial court shall summarily proceed to decide the issue and only deny it if it finds there's no agreement to arbitrate. And so I don't think any specific findings are required. I do think we could have taken the position, but we have not, that the trial court made those findings, that there is a valid arbitration agreement, and rejected all of the unconscionability arguments. I think we've conceded and taken the position that those are still live issues. JC Resources can raise all of those issues to the arbitrator. I think the one case that's most on point that we cite on this issue is the Allied Properties case. It's a 3-page appellate decision that basically says there's a delegation clause here. The party's claiming that it never signed the agreement. It got benefits under the agreement. It wants more benefits under the agreement. There's a delegation clause, so all of this goes to the arbitrator. I think that part of this case.
I'm not gonna assume they knew about the agreement though. I mean, because this isn't a case where they, didn't have a contract, then they had a contract and they started accepting, benefits. They had a contract under which they were accepting benefits, and your position is that contract changed. Their position is we didn't know about the change. So if you assume what they're saying is correct, right, that they didn't get the fax, I don't know, I'd be surprised all these pharmacies have fax machines still. I was a little surprised to hear it goes out by fax. But if you assume that they're right on the factual issue of we didn't learn about it, then they certainly didn't knowingly accept benefits under the contract because they were assumed they were under the prior contract that they were accepting those benefits, right?
Yeah.
Isn't there a knowing component for that accepting of benefits under the contract?
There is under the ratification argument. They try to frame it under ratification. It's estoppel. And here the record is very one-sided. We put in sworn testimony from our director of contracting saying this goes out, this provider manual goes out, it goes out to every pharmacy. What do we get in return? Basically in the record, crickets. It's attorney argument, but there's nothing from JC Resources. Not a single person at JC Resources was willing to put, their signature on something saying, we don't know about these updates to the manuals. I also think this is where the PSAOs are important. There's a lot of evidence in the record about how these pharmacies join these PSAOs. The main reason they do is to keep abreast on these types of things. The PSAOs get the updates. They're supposed to update their member pharmacies. So there's just overwhelming evidence that there was notice of our provider manual, of our updates. They accepted, $700,000 under the provider manual after it changed. They continued to accept money, in 2022, under that same version of the provider manual. So they can't now, and their dispute notification letter also mentions the provider manual. So I think it's too late for them now to say this is not a contract. And by the way, that argument's not in their trial court papers either. Something I looked at again, did they argue at all to the trial court that the provider manual is not a binding contract? And that's an argument they simply did not make.
Could you respond, please, to opposing counsel's argument that the cases that you have relied on to support Florida's jurisdiction are distinguishable because, his argument about Section 3 versus Section 4 and when Florida courts are at play and when they're not?
Yes, Your Honor. So that line of cases, they don't mention Section 3 or Section 4. I mean, these are cases, those 7 cases I mentioned, these are in Florida State Court. They're under Florida procedure. And the question is basically whether this Demora rule can take you out of Florida procedure so that a Florida court can avoid the arbitration agreement. And they don't address whether this is a Section 3 case or Section 4 case, because it doesn't matter. What the FAA supplies here that's important is this federal substantive guarantee that if you have a contract that involves interstate commerce and there's an arbitration agreement, the court, it doesn't matter what court, whether it's a federal court or a state court, must enforce it. And so we're in Florida State Court. We filed our petition under the rules as we're allowed to. And, given that it's governed by the FAA, the court can't, rely on some Florida policy or some statute that existed before 2013 to avoid the contract. So I think those cases are on point. I don't think they're distinguishable. I don't think the posture of, who filed first or who raised the dispute first matters. Under both the Florida Arbitration Code and the Federal Arbitration Act, there are 2 ways to get orders from a court compelling arbitration. And one way is if the other party files a complaint first and you respond to it with a motion to compel arbitration. And the second way is, a dispute is raised and you go to court and you ask for an arbitration. And this idea that there's not a live dispute between us, it's just incorrect. They sent a very formal notification of dispute letter. Words do matter. It is a term of art. It follows the procedure in the arbitration agreement. First step, send a letter with your disputes. Second step, meet and confer. Third step, arbitrate. We got to the third step. We asked them to arbitrate. They said no. And all the statute requires is an allegation that the other side refused to arbitrate.
Would you agree with this statement that the record is a little murky on whether they outright refused to arbitrate on that phone call? It looked like there was something in the record, and I could pull my notes to be more articulate about this, where they were saying we're not agreeing and we're not disagreeing. Something to that effect. And I understand your position that just by opposing this at the trial court level, and I read the case you cited for that proposition, that's good enough. But what about just the underlying facts as to whether they were refused?
Your Honor, two responses. One is going back to the statute. It really says allegation, and the statute has other things where the trial court's supposed to make a finding. This is just an allegation. We alleged very clearly in our petition that there was a refusal to arbitrate. And I hear what Your Honor is saying. I know that in their answer, they framed it as a denial. And they said, we were asked to arbitrate, and we said, we won't arbitrate future claims under your unconscionable arbitration agreement. To the extent that creates any murkiness, I think what's happened between that day and today, speaks volumes, because as your honors noted, the resisted our motion to compel arbitration in court. They've taken this appeal. And as that Vaden versus Discover Bank case that I think your honor is referring to said, it would be an absurd result if a party could get a reversal of an order to compel arbitration by saying it doesn't oppose to arbitrate. I mean, Mr. Rosen can come up here and say, actually, we don't oppose arbitration under your agreement, and maybe this appeal would be moot. But at every single step of the way, they have resisted arbitration. And so it's not just the allegation, which I don't think really was ever denied, but every step of the way is confirmed that they resist arbitration.
Aside from their litigating on its own, constituting a refusal, what would be if we were to just review that factual issue as to whether there was an initial refusal on that phone call, what would be the standard of review on that?
I think that would be substantial evidence. If there was a standard review for that, I think that would be substantial evidence, not de novo.
Competent substantial evidence.
Oh, sorry, I didn't.
Competent substantial evidence.
Competence. Yes, but again, the statute only requires an allegation, and the allegation was made. They had an opportunity in the trial court to demonstrate why there was no refusal. And once again, it would have spoke volumes to agree to arbitrate. We would have arbitrated and be done by now. But there's been just a constant refusal on that basis. And it's both the FAA and the Florida Arbitration Code that says an allegation.
Yes, if somebody, brought a petition to compel arbitration based on an arbitration agreement, and the other side, there just was no arbitration agreement, like it didn't exist. There was no document. For whatever reason, lawyer makes big mistake, doesn't raise it. Trial court compels arbitration, it gets up to us. And there just is there's never an arbitration agreement. Like it doesn't exist. There's no paragraph, there's no nothing, right? Just nothing exists at all, right? We're not arguing about the language and whether there's a delegation provision. There just is no agreement at all. Would we still say it was waived and that we can't reverse that because counsel failed to point out that just no contract existed at all?
Certainly, yes. I think that
That's the analogy I'm making is to the delegation provision, right? I mean, I think the Central District of California case is pretty well reasoned. And I'm saying, I'm looking at the language of the arbitration provision myself. It doesn't look like there's a delegation provision to me.
Your Honor, I mean, my response is that's what the trial court proceedings are for, to frame what are the issues that the judge has to decide. What are the factual disputes between the parties? What are the legal disputes between the parties? We put our position in a petition. The other side can deny or agree.
You just said if there was no agreement at all, we could still reverse. That's what you said a second ago.
I
think,
misspoke.
like the Rent-A-Center line of cases makes a really big distinction between the delegation provision and the remainder of an arbitration provision. It basically says the delegation provision stands alone and has to be independently challenged. And what I'm saying is, here, you said that if there just was no agreement at all, right, we could still reverse. If we find that there just is no delegation provision, right, and the Supreme Court has said those stand alone, right, separate from the rest of an arbitration provision, well, how do you win then?
I think I misspoke. I meant to say affirm. If a party asserts that there's a contract, the other side in the trial court concedes there's a contract. On appeal, if there's no contract, you still have the concession that there's a contract. There are mechanisms for a party to reopen trial court proceedings, ask for supplemental briefings, things like that. None of that has happened. I mean, we're now through the briefing at oral argument on appeal. Parties, especially, represented by competent counsel, are able to concede that contracts exist, even if for some reason they didn't exist. There's a variety of reasons why a party might take the position that a contract exists. After all, they're bringing disputes under this supposed contract. They want to bring claims under this contract. There could be good reason for them to concede why there is a contract.
The reason I'm framing it of whether something exists at all is just that the Rent-A-Center line of cases basically says delegation provisions stand alone, like separate not only from a contract, but from the rest of an arbitration provision, right? So even though there's clearly there's a contract here, there's a document, I think a reasonable person could look at this provision and find the complete absence of a delegation provision, which would for purposes of the delegation provision, be non-existent as it stands alone from the rest of the contract and the arbitration provision.
But I think my answer would be the same for that standalone contract. I mean, we have alleged and we put forth our position that that is a standalone binding contract, that delegation provision. The other side just, you know, argue that it's unconscionable, but never argue that it doesn't exist or that it's not a delegation clause. And so, no, I think if they waived it, you know, clearly this wasn't a side issue or something that didn't get attention in the trial court. This was, you know, this was a significant issue that received significant attention in briefing. And they, not just once, but repeatedly acknowledged there's a delegation clause. And their only argument was it's not enforceable. If there's no further questions. Thank you, Your Honor.
I have to speak really quickly because there are only 3.5 minutes. First of all, I would draw your honor's attention to the Marinette case, which lays out in detail. He's a trial judge, but he takes a holistic view of the facts. And he goes through this and said, they're not proceeding in good faith, which is precisely what the ANS court was talking about. They haven't proceeded in good faith. How can we ever prove a case where we can't take a single deposition? How can we ever prove a case where we can't get the documents we need? They've set up a system that's designed to fail.
Counsel, I want to ask you what, with respect to the issue about the Rent-A-Center line of cases as well. You challenge in your brief, but at least you say you are, the delegation clause specifically. And, you know, the Rent-A-Center line of cases says you have to do that. And I think it's a pretty tough standard because, you know, I would have trouble thinking of, and you could think about it in terms of scope, but in terms of validity, I'm having trouble thinking of an argument that would go to the delegation provision, but not the arbitration provision generally, right? But that seems to be what the Rent-A-Center line of cases requires, is that if you're going to challenge a delegation provision in terms of the validity, your arguments have to be specific to the delegation provision. And your arguments to me don't seem to be specific to the delegation provision. Like you bring up discovery. Well, discovery, you could certainly see what that would affect your ability to arbitrate the merits of the claims. But the delegation, how would the discovery issue pertain specifically to arbitrating the validity of the arbitration provision? Is that the Rent-A-Center says your arguments on that have to go specifically to delegation, not the arbitration provision as a whole, which seems to me to be a near impossible standard, to be honest. I'm looking at this and I'm like, what validity argument would possibly only go to the delegation provision, but not the arbitration provision generally? But that seems to be what Rent-A-Center requires. So which of your arguments go specifically to delegation in terms of the validity, but not the rest of the arbitration provision?
Well, I think they go to both. They go to both because.
Doesn't that mean you lose under
I don't
Rent-A-Center?
believe so.
Doesn't Rent-A-Center say that the arguments have to go to delegation specifically?
That's not how I read it. I would draw your honor's attention to the Volt case where the court was talking about how to interpret these things. I don't think Rent-A-Center requires that we prove the narrow issue. I think we've proven the holistic issue, which is, as the judge in ANS said, they've set up a series of rules to make it impossible to prevail. And I may have been born at night. I wasn't born last night. And the collection of all the evidence that we've submitted shows they wanted to have a separate arbitrator decide every single case on the same issue, even on the 250 cases that were consolidated. They've gone out of their way to design a system to make it uneconomical, impossible to litigate. That's why it's not litigated. That's why these cases can't be arbitrated. If they succeed in compelling arbitration, they're ending the litigation. There's no way to do it any other way. And that's what we think is holistic here. I would draw your honor's attention to the Marinette case, which makes that point, taking a holistic view. And it's your honor's question as to the order. The order says nothing on any of these other issues. There's no fact finding at all.
But the court didn't have to make any fact findings under a statute or any other legal requirement. Is that correct?
I believe that's correct.
No,
But he had to have some factual basis.
on whether they followed the procedure and all that. Wouldn't that all be a competent, substantial evidence standard for us to even review that?
There is no, it's impossible to make the evidence because there's no way to conduct any inquiry.
No, I mean, in terms of the court finding that they followed the procedure to get themselves to arbitration, right? Kind of the pre-arbitration procedure, even if we were to find that something we could review, if we were to actually review the trial judge's review of that, it'd be competent substantial evidence, wouldn't it?
I believe that's correct.
You'd like to wrap up, sir?
Yeah, I think I would draw your honor's attention to Volt case, which talks about if there's a conflict between the contract and the state law, it's the contract that governs. And the contract clearly calls for the application of California law. They were aware of that. They elected to do that. And as the ANS court has established, they haven't complied with that. And that's what's, we're going back and forth on now. They should have responded. Thank you. Thank you.
You will be adjourned.